of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody, and welcome to the show. Today we're talking about HOA, Homeowners Association, and understanding the rules and doing due diligence if you are a buyer in an HOA. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, you can find us on YouTube, and you can find us on X, formerly known as Twitter, and you can find us at the handle at INREM Podcast. That's at INREM Podcast. You can also download an audio version of the podcast. Just go to Spotify or Apple Podcasts or one of the other major platforms, download it. You can do it for free. Listen to us while you're pulling weeds in the yard. And leave us a review. We'd appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is a discussion on how to properly create and use land trusts, and in particular, how to properly create and use land trusts in the subject to transaction. There is a right way and a wrong way. And unfortunately, there's a lot of investors, gurus, other people out there that are promoting the wrong way. And so I want to address what that is. And then I also want to talk about the right way to do this. So the wrong way to use a land trust in a subject to transaction is to create the land trust and have the seller / borrower sign the land trust as grantor or as settler of the land trust, and then deed the property over into the land trust. And then to close the transaction, the buyer comes in, they take over the land trust, take over the beneficial interest of the land trust. They become the trustee of the land trust, or they have their LLC become the trustee of the land trust. But basically part of the closing is they come over and just be part of the land trust. And the reason why you do it that way, or that people are promoting to do it that way, is because when you amend the land trust, that's not a document of record. So when the seller moves the property into the land trust and they're showing as, grantor of the trust, and they're listed as grantor of the trust, then it looks like it's just a estate planning transfer. The lender doesn't really, know any different. And, they're less likely to call the due on sale. And then you come after that transfer and you change the beneficiary and the trustee of the land trust so that the seller no longer has any control, even though they were the original settler / grantor. But why is that bad? Why should you not do it that way? The reason why you should not set up the land trust this way is because Arizona, Wisconsin, and many other states have statutes that basically state that revocable trusts remain liable, and the property in them remains liable for the debts and obligations of the settler for the lifetime of the settler. So let me break this down for you. So if you go and you create a land trust and the seller signs it as the grantor, grantor is synonymous with settler. It's basically the person that creates and funds the trust. So if the borrower / seller signs the trust as grantor and then conveys the property into the trust for no consideration, they are going to be deemed the settler of that trust. And as the settler, if either before closing or after closing, they end up in hot water financially. So let's just say hypothetically, the closing happens, buyer is now in full control over the land trust, and this borrower / seller is driving around, and God forbid they cause an accident that results in serious injury or death. You're talking multi-million-dollar accident. Well, guess what? They're liable, but not only are they liable, but by law, that land trust is liable, and the property in that land trust is liable. So all of a sudden now the creditor has the right to come in and basically take the property and use it to satisfy the judgment. If the settler borrower ends up with credit card debt, IRS liens, any other, judgment against them, not only are they liable, but so is that land trust. And so is the property that they put into the land trust liable for those ongoing debts. And it's for the lifetime. So it doesn't matter if, these debts and obligations are incurred a month, 6 months, 2 years, 10 years after the transaction. As long as that property remains in the land trust, that property in the land trust is subject to the settler's debts and obligations. So that is the wrong way to structure and set up a land trust. The right way to do it is to structure it in such a way that the buyer on the purchase contract is the land trust, and the investor is the actual grantor or settler, and they create the land trust, and they initially fund the land trust with maybe $100. They put that money in there so that it's a fully funded and active trust. And then the trust actually buys the property from the seller so that the warranty deed goes from the seller to the trust. Now, there isn't any need to change beneficial interests or anything like that after the transfer. The seller basically conveys it to the trust, and the beneficiary of the trust will be the buyer's LLC generally. And that can be, a local state LLC. It could be a Wyoming, Delaware LLC, but it's the beneficiary. And then the trustee, there's numerous ways to do it for anonymity purposes. You could have the attorney be a trustee, a third party private fiduciary be trustee, but you can basically set up the trustee, how you want. But by doing it this way, you're not making the seller / borrower the settler or grantor of the trust. And so you're protecting that trust from future debts and obligations. Now, in Arizona, for purposes of the due on sale clause, if that's what you're trying to do, is try to provide a little bit of due on sale clause avoidance, because I will tell you, a land trust, even no matter how you structure it, is not generally going to be protected by the Garn-St. Germain Act. And if the lender finds out they can call the due on sale, it just creates a little bit of a deterrent for the bank, a little extra avoidance. But in Arizona, the right structure unfortunately doesn't work, which was why we don't do a lot of land trusts in Arizona. And the reason why the correct structure doesn't work is if I go out and I create a land trust and I list my LLC as the beneficiary, and then I buy the property from the seller, and the seller moves it into or sells it to the trust, the warranty deed is going to show a conveyance by the seller / borrower as grantor to my land trust as trustee. But in Arizona, and we're one of the few states that require this, I have to list on the face of the deed who the beneficiary of that land trust is, and not only who the beneficiary is, but the address. So if it's my LLC, I have to list my LLC. Well, if a lender looks at that, they're going to be like, oh, well, yeah, this trust isn't for estate planning purposes, because you normally wouldn't have an LLC be the beneficiary for estate planning purposes. And so they're going to realize that it, really is just a transfer to a third party trust, and, the due on sale is there. But in other states, it might work. And consult with, before you go and do this strategy and move forward with it, definitely consult with an attorney in the state where the property is located, making sure that you're setting up the transaction the right way, the trust the right way. Consult with an attorney, make sure you're dialing it in. But definitely do not make the borrower / seller, the grantor or settler of that trust in advance. Next week, actually, I'm going to talk about, even here in Arizona, how to do this. I'm going to talk about how to strengthen and use land trusts for full, complete anonymity for your real estate transactions. So tune in next week. I'm going to go through that on how to set that out, how to structure it, even here in Arizona, and how to even, even when you're going to do wrap financing and that deed of trust is going back to the seller, how to make it so that it's completely anonymous and no one knows, who's behind it. If anonymity is something you're looking to accomplish, you can do it with the land trust and structured correctly. So tune in next week for that discussion.
All right. Thank you, Sean. With that, a couple reminders and announcements for you, the listener. Today and every Tuesday at 2:00 p.m. Arizona time, we have the Creative Finance Collective. What is that? That is a membership or a grouping of professionals in the space of creative finance. Some of those are Sean and I here in Arizona, but we've got members that come in from Texas, from Georgia, from Alabama, from Ohio, from Florida. We've had them from all over the place. It really is kind of a niche group of individuals and professionals that practice in creative finance. But what we do is we get together, spend an hour each week talking about creative finance, talking about what we're seeing in other states, any changes in laws that are happening, news events related to real estate or creative finance. But what we're also doing is making ourselves available for the entire hour to you, the listener, for any questions that you have. So if you have questions about creative finance, maybe you're thinking about getting or utilizing creative finance, seller financing as a strategy. Maybe you've heard about it and it's something you want to try or get into. We talk about the risks, the rewards, the benefits, the disadvantages, everything from start to finish. And we take questions all along the way. And then we take questions until we stop getting them. So the longer we get questions, the longer we stay on throughout the hour. So it's important for you to engage and be prepared with your questions. So again, that's 2:00 Arizona time. We'll be on, and you'll be able to join that by Facebook, YouTube, or X. You can go to any of those and we'll be live broadcasting that. You can post your questions in the chat and we'll be taking those questions. Look forward to seeing you there. Also, today we're talking about homeowners associations and the due diligence you need to go and do with regard to HOAs when you're buying a property. So if you have questions about that, we'll take questions in the final 15 minutes of the episode. You don't need to wait till then to post your question. Post it in the chat. We've got somebody monitoring that chat. We'll keep track of it, and we'll address any questions at that time. So make sure as we go, if you have any questions, go ahead and post those. With that, let's go ahead and get into our episode today, which again, we're talking about the due diligence for purchasing property that's dealing with an HOA. And with us to discuss HOA and HOA management is Paul McFarlane. Paul, thanks so much for joining us.
Thanks for having me, guys.
Yeah. So, Paul, I understand you're an owner and designated broker with ProX Realty Management. Tell us about your company.
Yeah, so I've actually business partnered with Augie Penev. We've been in business ProX has been in business for over 3 years. He and I have been partnered for a little over a year. But from a management perspective, I've actually been in some capacity of real estate management for a little over 2 decades now.
Okay. So give us an idea about what ProX Realty Management does. Is it mainly engaged in the management of property for owners?
Yeah, well, it's full service real estate management. So not only residential real estate management, we also manage commercial properties as well as some owner associations. We specifically do commercial owner associations and very small HOAs. So typically custom built homes, no more than about 25 homes or less that we manage.
So Paul, explain your journey a little bit. How did you end up working in real estate? How'd you get into that business?
Wow. So I was in IT, electrical engineering degree, and I got into IT outside of after I graduated. And then 9/11 happened. I was back on the East Coast, born and raised in New Jersey, and at that time got laid off. They were downsizing, and my mom mentioned to me, "Why don't you go speak to our broker who helped us purchase our investment property?" So I went and spoke to him. Got my real estate license and fell in love with real estate. Commissions are great, but having a steady income is even better. So from that, I got more into management because I was providing steady income, and then obviously the commissions were an added plus on the back end. So started with managing very small residential properties, small portfolio of single family homes up to about 5 homes. And then from there, dove a little deeper into HOA management, where I started off as a portfolio manager. Portfolio managers typically manage multiple associations. So at the time, I started with about 5 different condo associations. From there, took it up to another level where I was managing a master association, which consisted of about 3,600 homes and with 13 subdivisions within them. So I've had a taste of all different aspects of HOA management, from very small scale to very large scale, and have been doing it ever since. Came out here to Arizona, was able to leverage my license and experience out here to get my broker's license out here. They obviously do things very differently here in Arizona than they do back east, which is a fun learning experience to say the least. But got my broker's license, and then just through networking, through multiple channels, have been able to build a business.
So Paul, walk us through. So we're gonna get into kind of all facets of homeowners associations. You obviously deal with them at a much higher level than the common person is. I think most people have some sense of a homeowners association, but just to lay some groundwork, if we've got a listener who's basically crawled out from under a rock
Yeah.
where they've been for who knows how long, and this idea of homeowners associations is a new thing for them. Why don't you go ahead and lay the groundwork and explain, at a base level, what is a homeowners association?
So, at a base level, an association is established by 3 main documents. One is the Articles of Incorporation. That's how the actual entity is created, and it is a nonprofit organization. That's number one. Number two are the bylaws. The bylaws are how the board is established, how meetings are held, each position within the board, and their responsibilities. And then the third and most important is the CC&Rs. That's the meat and potatoes of the HOA. That's where you'll get to find out essentially what you can and cannot do within a community that you're potentially going to be buying into. So I know that a lot of people, when they're going through the home buying process, it's very overwhelming. There's so much documentation being provided to you between the contracts and all of these disclosures that are being sent to you. If you are going to buy into an HOA, I strongly, strongly, strongly recommend that you read the CC&Rs, especially if you're planning to do whatever with inside that community. Make sure that it's allowed, and all that would be identified in the CC&Rs.
So to talk to us, so we obviously have, like you mentioned, the covenants, the CC&Rs that are recorded against the property. Then you have the formal creation of the homeowners association itself. You mentioned that with the formation, the Articles of Incorporation, that it's a nonprofit organization.
Yep.
I'm thinking back in my practice, I've seen examples where you might have covenants and restrictions, but no formed HOA. And that's kind of another topic.
Yeah.
But what is the idea? Why form an association? What at the end of the day is the value add that they're providing to homeowners? What is it that they do?
Essentially, they're looking for uniformity and compliance. So uniformity from a standpoint of, if you're in an HOA that has a certain color palette of colors that are allowed on homes, you don't want somebody that's going to come in that buys into the HOA that's going to change their house to a black and white or a pink color or what have you. So in addition to that, it's also making sure that people are properly taking care of all of their areas that they're responsible for, which are called the limited common elements. Those are specific to that individual owner. So in a condo, it would be their balcony. In an HOA, it would be their yards. You want to make sure that they're not storing excess material on balconies. They're not letting weeds overgrow within their front yard, which I know is a huge, huge, huge topic of conversation out here in Arizona with weeds, especially this time of year with the amount of rainfall and how weeds do grow out here. But the HOAs are there to enforce the rules that are established within the CC&Rs that were there long before anybody has moved into these communities. But just to make sure that the overall aesthetic and the appearance of the community is consistent throughout.
So talk to us a little bit about what is an HOA actually responsible for? And I'm guessing it's dependent upon the type of community you have, condo, townhome, single family residence, even commercial. But what generally is the association going to be responsible for within that community?
Yeah, so great question. So if you have a condo association, typically the HOA is going to be responsible for the building itself. So they're going to be responsible for maintaining the roof, making sure that they have adequate insurance for that building, in addition to the common area. When you get into planned unit developments, PUDs, or associations that are single family homes, the homeowners are responsible for their own roofs and for their lot itself, where the HOA is going to be responsible for any common area and or amenities for that specific association. So if they have a pool, if they have a tot lot, if they have a retention basin area, typically your HOA dues are what's going to pay to manage and maintain those things within the community.
So obviously the rules and regulations are important to most buyers. I mean, at the end of the day, HOAs probably get a lot of flack because of the bad things people perceive that are going to happen. But the reasons a lot of folks will buy into an HOA is because there are rules. There are rules and requirements that ensure that when I go buy my home, my neighbor isn't going to put a giant RV next to my property, for instance, or some other, a trailer that doesn't look very nice or whatever else. So, it's a bunch of rules that the entire community has agreed upon that they're going to agree to govern themselves by. But when I say in a community's agreed to these things, maybe some owners or a developer agreed to these things early on when they developed it. But most people coming in buy into these rules. Maybe they know what's in them. Maybe they don't. Usually they have a pretty good idea, having lived in an HOA, what they might come to expect.
Yeah.
But you mentioned before that it's important to review those CC&Rs, those rules and restrictions, before you buy. When does a buyer have the opportunity, and how would they get those documents when they're first kind of deciding, is this the subdivision I want to live in? Is this the home that I want?
Sure. So typically, whenever you have a property that goes under contract, the buyer has within 10 days to receive a copy of those CC&Rs and review them. So it's typically the same time frame that's established with a normal inspection. So during that time, the title company will reach out to the statutory agent or management company of that association and request a list of documents to be provided to them. That list of documents includes the articles of incorporation, the bylaws, the CC&Rs, if there's any rules and regulations, a copy of their operating budget, a copy of all their existing and current financials for the property, and if there's any other specific documents related to that association, all of that is provided to that buyer. So that within that 10-day period, they can review those CC&Rs, those rules and regulations, to make sure that it is a community that they do want to buy into. So 10-day period is within that inspection period is when it's distributed to them.
So what is some of the due diligence items that you would want to either locate within the documents or even find out about the community to decide, is this a community I even want to live in? What are some things that buyers should be thinking about, when getting ready to close on a property in a HOA community?
Yeah, so there's a few things, and obviously each investor and or homeowner, the story is going to be a little different. But the main thing is, one, if you're looking to make it a rental property, make sure that the CC&Rs allow that. The majority of them, from what I've seen, it's a minimum of a 30-day occupancy for any rentals in that property. So make sure that you're compliant with that, especially with Airbnbs. There's certain municipalities that are starting to crack down on that. That's one. Number two is to check their financials. Have they been through a special assessment recently? Have they increased their dues every year for the past 3 to 5 years? Do they have a reserve study that's been done? And for those that are unaware, a reserve study is basically a capital improvement plan and project for the community. So if you want to do any capital expenditures within your subdivision, an example would be repaving the streets or changing the roof. If you're doing any of those large projects, you want to make sure that when you're ready to do those projects, you have funds set aside and allocated for it. That's actually a line item within an association's budget. There's a certain amount that's pulled out every month, put into a savings account. So then when that project is ready to start, the funds are already allocated and set aside for that. So financials is definitely something that you want to look at to make sure that it's been adequately funded. Another thing you definitely want to look at is the amount of delinquencies that are within the community as well. If you have a lot of people that are not paying, then you're obviously going to have a lot of legal fees on the back end of that to help offset those delinquencies to try and collect on that. So between the financials and CC&Rs and the reserve study, I would say those are the three main things that you'd want to look at to make sure that there's adequate funding and making sure that there are things within the CC&Rs that are not going to prevent you from doing what you want to do within that community.
Well, what about though, and you know, I've experienced this personally within a community that we used to live.
Mhm.
What about those HOAs that are just over the top with, you know, fines and regulations, and they basically don't let people really just live?
Yeah.
How do you kind of sort that out to make sure that, hey, this isn't one of those HOAs?
It's the rules behind the rules,
Yeah.
right?
Right.
Yeah. So the best way I can explain that is it's going to depend. And it's depending on two things. One, it depends on the manager that's managing your community. Two, it could be the management company. But three, it could also be the proximity of your house. What I mean by that is if you live across the street from a board member who has to walk their dog every day and look at your weeds every day, they're going to be calling the management company on a daily basis to ask them, have you sent them a letter? Have you sent them a letter? So it really depends on who's managing your community and your proximity of where your house is within the subdivision. It's an unfortunate scenario to have to be in to even want to have to ask that question, because you do want to at least be entitled to quiet enjoyment and privacy and not be a victim of a constant nuisance violation. But like I said, it really depends on the manager, the company, and the proximity of the property. But I do think that a lot of times, a lot of these issues can be mitigated by just having a simple conversation with your manager, and or going to a board meeting and talking to board members and just getting an overall feel of what their vision is for the association. They are, again, there to maintain and enforce the CC&Rs, but as we all know, people are people, and a lot of times some board members and or managers may have certain agendas or what have you. So it's important to stay informed, but also to communicate. Those two things, I think, can help mitigate a lot of problems within these subdivisions.
So, and I do want to dive in and talk about the whole thing about management companies, because I think, frankly, they're a real problem here in Arizona. So even more recently in my community, we've changed managers, and this new manager is very fine happy and fee happy. And so what I mean by that is one example is the fact that Arizona law provides that if somebody's delinquent on their assessments, by the CC&Rs, they have a lien on the property. And it even says in the statute, no additional filing is required. Well, this management company files a lien and uses their own in-house document preparer to file the lien at $500 to the homeowner, right?
Wow.
So that's just money in their pocket, right? They're just
Sure.
lining their pocket. And then, they also negotiate as part of their, contract that they get, at least a percentage of the fines that they are able to collect and things like that. And so they're all running around, trying to find. So who regulates these management companies so that, like, if they're doing the stuff that really they shouldn't be doing, you can go and file a complaint with some government agency to have them, investigated and their license, pulled or suspended?
Sure. So there are some governing entities within the HOA industry. On a national level, it's CAI, the Community Associates Institute. On a local level here in Arizona, it's through AACM, the Arizona Association of Community Managers. Those management companies and managers that are members of these organizations are held to a higher standard. I would start there to just see if they are registered there, because you're right, there are quite a few management companies that are out there because they're not regulated. They're doing things like you just mentioned. So I would start there by looking to see if they're registered. As far as complaints are concerned, the Department of Real Estate, there is a division there that you can, if you're not getting any responses back from the HOA, you can file a complaint with them, but the company is not required to have a license. So the Department of Real Estate is only limited by basically complaints. So I would start there just to make sure that the company is actually a company that's being recognized by the higher standards set by CAI and AACM.
So if I hear what you're saying correctly, after this show, after Andy and I receive this extensive knowledge from you regarding HOAs, we could go form an LLC called HOA Managers LLC, and we could advertise ourselves as being able to manage associations. And we don't have to go and get licensed with the Department of Real Estate, with the Department of Financial Institutions, with any other state department here in Arizona. We simply just form an LLC, hang a shingle, and say, we can manage your HOA for you because we had this great conversation with Paul and we learned so much. We're good to go. I mean, that's accurate, right?
I would say that's accurate, but I'll also say consult legal counsel to make sure that
right.
That's all on the up.
But you should be doing that.
Yes.
I get that.
Yes.
That you should be doing that. But in theory, somebody could do that.
Theory, in theory,
yeah.
yes.
Yeah.
Yes, absolutely.
Yeah, because there is no state agency. And that's a plug for you guys, right? Because you are licensed with the Arizona Department of Real Estate.
Right. So there's a difference between having an HOA management company and being a licensed realtor and agent within the state of Arizona. So our organization is held to a higher standard just because I am a broker in the state of Arizona and I do have a broker's license, and they do have rules and regulations that I have to abide by. And especially from a property management standpoint, have to make sure that my books are in compliance on a monthly basis. I'm constantly reconciling. Whereas an HOA company, yes, you are supposed to be providing your financials on a monthly basis to your communities, but there's really no governing body that's regulating that or making sure that that's being done. So yes, that is a higher level of standard care that we do practice.
One last thing, and then we'll move on.
Sure.
Talking about the professionals behind the HOA.
Sure.
But what research should go into the law firm that represents the HOA? Because my experience in Arizona is there are certain HOA law firms that are way better than others. In fact, I had one that literally stole, and I was able to prove it. This HOA lawyer, he stole from both the HOA and my client by increasing the amount of the judgment against my client for amounts that weren't owed. And we finally were able to team up with the HOA because it's theft.
Yeah.
And, the judge, unfortunately, didn't turn him into the state bar, but ended up, slapping his wrist, making him give us all the money back because he claimed it was just an accounting error, type of thing. And so we weren't able to improve. Yeah, we weren't able to improve it in intent. But, some of these lawyers, and they charge on contingency fees. So the contingency fee is I get my money from the delinquent homeowner when they finally pay their judgment. And so what kind of investigation maybe would a buyer want to do to figure out what law firm does the HOA use, and what are you looking at as far as how they charge, how they collect, how they're going to get their money if, you ever, end up with a delinquency?
I'm going to refer back to the two entities from before through CAI and AACM, the Community Associates Institute and Arizona Association of Community Managers. Again, these professionals that are members of these organizations are held to a higher standard. So I would definitely start there and see if they're members of those organizations. In addition to that, obviously, if somebody says they're a practicing lawyer, you definitely want to dig a little deeper and just make sure that they are competent in HOA law, that they're not just a standard business lawyer or any other kind of law not specific to HOA. And that I believe you can research either on them or I'm not sure if the bar provides that kind of information when they do register in terms of their specialty, but again, through CAI and AACM, you can definitely see who's being regulated and being held at a higher standard.
Paul, I want to delve a little bit further into kind of what I mentioned before, the rules behind the rules, or the story behind the story. Because when I'll bet you we're not going to find very many people that when we review the CC&Rs that we disagree a whole lot with what the CC&Rs say. I'm going to read the CC&Rs and it's going to say, I got to keep my yard kept, right? Who's going to disagree with that? I want my neighbor to keep their yard kept. I want to keep my yard kept, right? I don't want a boat parked right next to, my driveway. All those, everybody's going to be in agreement with that. That's why they're moving to the HOA. The thing that we're always worried about, and we talked about this before, but the HOA that is overly sensitive to a tiny blade of grass that suddenly appears and I get constantly fined because I didn't get to it in the 35 seconds before it just popped out from the rocks, kind of thing. That's the overbearing board or management company that they're worried about. So the kind of the heavy enforcement action that comes behind these rules. What can a potential buyer do to work through that and find out if that's a problem? Now, you mentioned before one interesting thing, which I thought was interesting, your proximity to a board member's house. So you could, in theory, find out who the board members are, find out where they live, deed information and assessor's information is public. That's probably not that difficult to find. That would be one way to do it. But what's the other way to find out? Just is this community's sense just overly burdensome in its enforcement actions? What are some things buyers can do to work through that? Do they knock door to door as to neighbors? Do they go on social media? What would you suggest they do?
So obviously you can talk to neighbors, and yes, it is all public information where people do live. But one thing that buyers can do in addition to that is get a list of the violations that have been filed against the property for however long that the property has been there. So you'll be able to see a history of any of the violations that have been occurring there. What I will say in addition to that is violations don't reset with new homeowners. And what I mean by that is if you've received a violation and you've been getting fined excessively for weeds at your property, you sell the property, somebody else moves in. If weeds start again, you're already on their radar for weeds. So it's definitely something that you want to do some due diligence there. And it is something that you can request from the HOA about the history of violations for that specific lot to see if it is going to be a recurring problem or not. So that would also be included as part of the due diligence process to request that documentation.
So question for you on that. What is the duty of the HOA to disclose known violations for the property? Meaning, let's just say hypothetically that they've sent a letter to the prior homeowner saying, hey, your house needs to be painted and you have X amount of days to paint. Seller doesn't paint, buyer comes in, buyer opens escrow, they get their disclosure from the HOA. What's the duty of the HOA to, let this buyer know, hey, look, this house needs to be painted and somebody's going to be painting it soon?
Again, that's another disclosure document that would be provided. So if there are any existing violations on the property, that is something that has to be disclosed by the HOA within that 10-day period. And then typically, if, for example, the example that you used, Sean, if the house does need to be painted, and let's say that the current seller does not want to paint the house, it would be a technical violation that would be transferred, or they would have to address it prior to close of escrow. So that is something that the buyer would have to negotiate with the seller to see if they'd be willing to provide them like a credit or something like that to have the house painted, because it technically is their responsibility. And within that 10-day inspection period, if the buyer does find that the house is currently in violation of anything with the HOA, they do have the opportunity to pull out of that contract. So it's definitely something that can be negotiated with the seller, that the buyer can obtain that information from the HOA as part of their due diligence and then potentially negotiate.
Now, let's say hypothetically that they sent this letter to the seller, said, hey, seller, got to paint that house. Seller doesn't, they enter into a contract, seller doesn't disclose it. The escrow company goes to the HOA, because that's normally who requests the disclosure, right? The escrow company goes to the HOA and says, hey, give me your state required disclosures. And the HOA fails to send that letter or that notice that the house needed to be painted and doesn't say anything about it. And then buyer ends up buying the property. Does the buyer now with the violation there, but they don't know about it because the HOA didn't disclose it?
Wow. Does
the buyer then have to paint the house, or is the HOA stuck with an unpainted house for as long as the buyer owns it?
That's a great question. So and just to recap the scenario, you're saying that seller did not disclose it, but it's typically the HOA that's going to be the one that's sending the letter to the seller that they're in non-compliance. So
yes,
even if the seller does not disclose it, the HOA would disclose it in their disclosures and packages. Now, if all of that is missed, again, I'm not an attorney, but I do think there is some legal recourse there, that if it's not disclosed that it's something that was in violation, that the buyer could potentially fight that. But that's definitely a legal question.
Yeah, we actually had that happen, a very similar scenario. And not me personally, but another attorney that I knew had that happen to him, of all people, an attorney.
And the HOA tried going to him and saying that he needs to now paint the house and he's in
violation? And basically went back and said, no, you didn't disclose it. And so I can basically leave my house unpainted while I own it. And then of course, when they go to sell it, then they have to
paint it or address that.
Or address it, because at that point the HOA, but they couldn't force, they could own it for 20 years and never paint it at that point, even though it really needs to be painted potentially, because the HOA didn't give that disclosure.
There's typically no time frames established with painting houses in HOAs. It is somewhat subjective based on the people that are inspecting the homes. So, but if either the manager or a board member walks past the house and there is significant paint chipping and stucco patching that needs to be done at the property, they can definitely send him the notice that it needs to be done. But as far as that whole process of selling the property with him taking it with an existing violation on there, then yeah, that's definitely more of a legal issue for sure.
Yeah, it ultimately, when it was researched, I will tell you the HOA was just stuck with it, even if they later found chipping and whatever, because the problem is, it gets back to what you were saying before, a level of fairness, which is, had it been brought to the buyer's attention, the buyer could have gone back to the seller and been like, hey, you need to paint this or I'm walking.
That's right.
And could have basically renegotiated and instead now the HOA is wanting the buyer out of the buyer's pocket after the transaction closed
Yeah.
to paint. And,
Yeah.
so unfortunately the HOA is,
They're screwed.
they're screwed at least while they own it. And then, they could, when that buyer goes to sell it, they can put it into the disclosures and disclose it properly at that point.
Sure.
So.
Interesting.
Paul, one of the type of folks that watch our show are real estate investors, and a lot of time investors are looking to take a distressed property, fix it up, and sell it for more money. Pretty, not rocket science, but oftentimes when they're doing that, they're maybe almost all the time they're doing that, they're dealing with a homeowners association. And when you're talking about doing certain things in a homeowners association with regard to construction, design, or change to the property, not only is there a permitting process with counties, cities, so on and so forth, government, municipalities that you're dealing with, but there's also a process typically within homeowners associations in which you have to do.
Correct.
Okay, so that's not news usually to most investors, but time is money for investors. And there's a couple things that they want to know. One, how long is this going to take? And two, knowing, maybe having done it, how long it's going to take. Many of them are going to want to ensure that the homeowners association they're buying into has their act together, that they're familiar with this process, that they can bring applicants that are working to get approvals within the process, that they're going to process them efficiently and effectively, and they're not going to be left languishing. One, I guess the first question is, what should buyers expect this process to typically take in a kind of a standard homeowners association? And two, are there ways that a buyer can do some due diligence and investigate to see whether an HOA has its act together and they're going to be reliable when it comes time to submit this process in order to do construction work on a potential flip?
So to answer your first question, as far as time frame is concerned, typically it's going to be about a 30-day process. But there are some communities, and obviously it varies depending on the community that they buy into or looking to buy into. But there are some architectural committee that are the people that are reviewing this. So there are some communities that meet on an as-needed basis. So that is something that can be asked of the HOA to find out how often the architectural committee does meet. Because again, if it's going to be a 30-day process and they're trying to close within 15 days, obviously there's going to be a conflict there, especially if it's something that they're looking to do. So it is something that they can reach out to the management company or the HOA to find out what is the typical turnaround time for an architectural review process. That would be my recommendation. And yeah, again, there are some that meet on an as-needed basis very frequently throughout a month, but typical time frame is about every 30 days because you do have board meetings that are held every 30 days, some quarterly, depending on the size of the association. So if there are any architecture requests that are being submitted that the board may need to give some insight on, they typically have those conversations at these board meetings. One thing to keep in mind in the big picture of all of this is, again, within these HOAs, one, it's a nonprofit organization. So all of these people that are on the board are homeowners within that association who are volunteering their time to manage this association. That goes the same for the architectural committee. These are people that are volunteering their time. So you have to be a little mindful of that. You do have your regularly scheduled board meetings, but the architectural committee meetings are going to vary depending upon time and availability of the people that are volunteering for those committees. So check with the HOAs or management companies to find out how frequently.
So in Arizona, there's certain statutes that govern HOAs and the conduct of HOA boards and meetings that are different than what maybe your typical bylaws or statutes would allow of just any, company or corporation within Arizona. And one of them, and I think a lot of HOAs struggle with this, is open meeting laws. Can you talk about what Arizona provides as far as, open meetings? What is an HOA board required to do to comply with those open meeting requirements?
Yeah, so there are statutes. Obviously, within their bylaws are the bylaws of the association. There are policies and policies and procedures of how to conduct open meetings, but that's on the call it the ground level, for lack of a better term. You do have the PUD statutes, the planned unit development statutes, that also are another layer of how open meetings are supposed to be conducted. It's basic proper notification of these meetings, allowing owners a chance to speak. You can't just let somebody come to a meeting and say you can't say anything. You have to give them the forum to speak. Now, you can regulate the amount of time, but it's best to just set that precedent up front that each owner will be given X amount of time to say whatever they need to say. So between the existing bylaws of the association and the statutes that are on a state level, just overarching, it is just making sure that people are properly not notified and given an opportunity to speak on their behalf at these meetings, and also be provided with documentation that's requested. That's not specifically legal related to any legal matters going on within the association. Any public information that owner is requesting, i.e. financials, if they want to see reserve studies, anything that deals with the day-to-day operations of the association, an owner is entitled to that information. A tenant is not, but an owner is.
Paul, I know, having the fact that you're in the property management business, you've seen all sorts of horror stories and probably could write a book about all the levels of due diligence that a buyer ought to go through.
Sure.
Beyond what we've discussed today, is there another area of due diligence you think is important for a buyer to consider, or one that you would be like, man, we haven't talked about this, but if you're buying, you need to check into this before entering an HOA?
I would encourage, I guess it's two levels. If it's a first time home buyer or somebody that's going to be buying into the community, I would highly recommend going to the property during the day and during the night. They're two completely different scenarios that are going on at the property during the day and during the night. I specifically can speak about my subdivision, where during the day, everything looks great. Everybody's got their garages. There's no on-street parking, which I do appreciate. But on the back side of that, the parking spaces that are allocated within the subdivision is not adequate to be able to help everyone within the community. So from a homeowner that's looking to buy into there, definitely go to the property during the day and during the night. From an investor standpoint, it really just comes down to making sure that any kind of modifications that you're potentially looking to do to the property on the exterior, on the interior, you're allowed to do what you want to do within, I want to clarify this, within single family homes. If you're in a condo, there are restrictions, especially if you're on the second level. If you're looking to make any kind of modifications, there are certain restrictions that are in place within the condo associations. They are going to require a certain layer of thickness of subflooring and making sure that there's adequate insulation, things of that nature. Single family homes, typically there's no restrictions there, but just making sure that whatever the investor is looking to do at that property, be it an Airbnb, be it add a second level to the property, add another bathroom, whatever the case is, definitely check with the CC&Rs to make sure. So I think that would pretty much cover you from a due diligence standpoint to making sure that everything's going to be addressed.
I like that, because when do you go visit a property? It's with your real estate
It's always
agent,
during the day.
when the sellers are away, when
Yep.
the whole subdivision's at work, right?
Exactly right.
So you
Exactly
go
right.
and it's like, wow, this is a quiet subdivision.
Yeah.
But then you get there at 7 p.m. and it's like, wow,
Totally
this is
different.
party central.
That's when it comes alive.
Yeah.
Nighttime when everybody's home.
Yeah. Oh, good information. Paul McFarlane, Tell our listeners where they can find and connect with you online.
Yeah, so online I'm at PM the PM. That's PMTHA PM. Paul McFarlane, the property manager, is my Insta. ArizonaProX.com is the website, and Paul at ArizonaProX for email. I do enjoy having conversations, so please reach out to me at any time. Anything I can do to assist, I'm glad to help.
All right. Well, Paul, thanks so much for joining us. That's Paul McFarlane, owner and designated broker with ProX Realty Management. Paul, thanks so much. Let's do it again.
Thank you, gentlemen.
All right.
Thanks, Paul.
With that, everybody, that is our show. Make sure to join us at 2 p.m. for the Creative Finance Collective, and we'll see you next week.
Have a good day, everyone.